The Supreme Court gets set to hear what could be a landmark case on two big questions: whether President Trump can end birthright citizenship by executive order, and whether federal judges are overstepping when they issue national injunctions to stop that and many other government policies.
From the opinion pages of the Wall Street Journal, this is Potomac Watch.
Welcome, I'm Kyle Peterson with the Wall Street Journal. We're joined today by my colleagues, columnist Alicia Finley and editorial board member Monet Ukwe-Barua. On his first day in office, President Trump issued an executive order intending to reinterpret a long-standing consensus on the citizenship clause of the 14th Amendment. Ratified after the Civil War, the 14th Amendment begins this way, quote, "All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States," unquote. With certain narrow exceptions, that has long been taken to mandate birthright citizenship as a right of anyone born in the territory of the United States. President Trump now wants to deny that citizenship to children whose parents aren't legally and permanently in the country, including illegal aliens and also those visiting the U.S. on student visas or tourist visas. The order by President Trump is on hold after judges issued a series of nationwide injunctions to block it. But on Thursday, that and the merits of the case may be up for grabs at the Supreme Court. Let's start with Donald Trump in the Oval Office last month giving his view of this appeal.
I am so happy. I think the case has been so misunderstood. That case, birthright citizenship, is about slavery. If you look at the details of it, the signings of it, everything else, that case is all about slavery. And if you view it from that standpoint, people understand it. But for some reason, lawyers don't talk about it. The news doesn't talk about it. That's not about tourists coming in and touching a piece of sand and all of a sudden they're a citizenship. They're a citizen. That is all about slavery.
Alicia, let's start with the merits of Trump's executive order. What's your view of the meaning here that each side is taking of the 14th Amendment?
Well, it's novel, but conservatives or some conservatives have been arguing this for a while, that the 14th Amendment shouldn't apply to illegal or undocumented immigrants or those who are only in the country temporarily. And their claim is that under longstanding precedent, which was the Wong Kim Ark Supreme Court decision, 1898, that determined that birthright citizenship applied to the child of two legal residents. That actually case didn't extend to illegal immigrants or others who are just in the country temporarily. So they want to cabin that ruling and are seeking to reinterpret the 14th Amendment. And their argument is essentially that illegal immigrants or others aren't really subject to the jurisdiction of the United States. They're subject to the jurisdiction of other countries, and therefore that are not entitled to birthright citizenship. I'd also just point out that I think part of this is really intended as a deterrent. This is a policy or a political move as much as a legal one. I think they're trying to deter people from coming to the U.S. By creating this the legal uncertainty about whether, if they have a kid in the U.S., whether they'll actually receive citizenship, and then if they get deported, what happens then? And there are some who actually want to limit birthright citizenship, but others in the administration, I think, really just want to use this as a immigration deterrent.
A couple thoughts on that 1898 case, Wong Kim Ark. Part of what the Supreme Court said in that case is that the 14th Amendment affirmed the ancient and fundamental rule of citizenship by birth within the territory, unquote. And Monet, I think Alicia's right in describing the debate here. One side says, well, Wong Kim Ark's, his parents were not illegally in the country. So the question of whether that applies to people who are illegally in the country is still an open one as a matter of law. But a couple points there. One is that President Trump's order also applies to people who are legally in the country, if temporarily. And also, supporters of the majority understanding of birthright citizenship say, well, that Wong Kim Ark case predated much of modern federal immigration law. So there was not really the same kind of distinction between legal and illegal immigrants back in that day than there is today. We had an open frontier for many intents and purposes. And so part of what I think is the difficulty here is the plain reading of the text of the 14th Amendment, that subject to the jurisdiction language. The court in Wong Kim Ark said that there were some exceptions. One would be people who are diplomats who are having children in the United States, which makes some sense. They're not subject to U.S. jurisdiction. They have diplomatic immunity. Famously, in New York City, the UN comes in, and all these diplomatic cars get parking tickets, and many of those parking tickets, to the city's annoyance, don't end up ever being paid. The second exception would be enemies who are in occupation, hostile occupation of U.S. territory. If a foreign army conquered some corner of the United States, that by definition almost would no longer be subject to the jurisdiction of the United States. And so, I mean, Monet, I guess I'll get off my soapbox here, and you can take this whatever direction you want. But it does seem to me that at the very least, the Trump interpretation of this is fighting the majority consensus of what the 14th Amendment means.
I agree with that. And I think that different parts of the Trump executive order on birthright citizenship were more egregious than others. So you were right to pull out the provision that denied birthright citizenship to the children of visa holders, people who are on temporary visas like student visas or work visas. I think that several of the judges who enjoined the Trump executive order, which we'll get into a little more later, pointed out how egregious they thought it was as a matter of law. And I think that that's especially true with regard to the visa provisions, because any reading of Wong Kim Ark has to suggest that someone who is legally admitted to the country would fall under that jurisdiction provision within the 14th Amendment, and therefore their children would be entitled to birthright citizenship. With regard to the question of illegal aliens, I agree that the plain reading should suggest that they are still subject to U.S. jurisdiction. They aren't the children of foreign diplomats or Native Americans who were conferred some kind of special status as belonging to a quasi sovereign entity. But there is a little bit more ambiguity there. I think it is interesting that the Wong Kim Ark decision did specify that Wong was the children of parents with a permanent U.S. domicile. And it's true that there wasn't an equivalent of U.S. immigration status or visas in 1898 the same way that we have today. But his parents did come in through essentially the San Francisco version of Ellis Island. They were being brought into the country, and they went through some kind of processing facility that noted that they had arrived. They were going through some kind of formal process as opposed to just crossing the border and evading detection in the same way as a lot of illegal immigrants today. And so I do think that the Trump administration is very likely to lose on the merits, both for visa holders and for the children of illegal immigrants. But the Supreme Court will have the opportunity to really clarify the status of the children of illegal immigrants. We'll be able to point to the historic record for why they should be considered to fall under the law. And that isn't crystal clear today.
One question is how the justices will direct this oral argument and whether they will decide to get to the merits of birthright citizenship at all, which brings up the second big question that is before the justices. This executive order by President Trump was blocked in nationwide injunctions issued by 3 district court judges. The Trump administration appealed that, and there were appeals courts that declined to intervene and to stay those injunctions. And now the Justice Department has appealed to the U.S. Supreme Court. That is how we get here on the emergency docket, this case. And notably, in its initial filings to the Supreme Court, Alicia, the Justice Department does not spend a lot of time on the merits of the birthright citizenship question, which doesn't mean the justices can't go there if they choose to. But the government is framing this as an appeal on the question of nationwide injunctions. And I think some of the complaints about those are warranted. I mean, basically, the status quo that we have here now is the party out of power. Anything that the president, the government tries to do will run to a friendly form somewhere in some corner of the United States. It might be San Francisco or it might be Texas, and ask a single district court judge to block some new government policy everywhere from Alaska to Hawaii to Florida for all 340 million people living in the United States. And the question that the Justice Department is teeing up here is whether that is an overreach, which is a question that applies more broadly than just this question of this argument over birthright citizenship. There have been many nationwide injunctions issued in the Trump term, but I would also have to say in the Biden term as well, and under President Obama.
Right. So, I mean, this issue of nationwide injunctions is kind of thorny. Conservative justices Neil Gorsuch and Clarence Thomas, in particular, have criticized them, and so have actually some lower court conservative judges on the appeals courts, and they've actually tried to restrain some of the lower courts, the district courts that have issued overly broad injunctions. And I've seen that especially in the case of the Sixth Circuit, where you have in some extent even the Fifth Circuit who has come in and said, no, 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 you guys are trying to block a rule across the country. Just do it with the specific parties in the case. And some of the problem stems to the issue of legal standing, and that's the doctrine that or bedrock principle that you must have suffered a concrete injury that can be traceable to a particular action. And some lower courts have granted standing willy nilly to particular plaintiffs. And I'd say both liberal judges and certain conservative judges have done that. And this has enabled them then to issue broad injunctions. So that's one issue. Is that sometimes they just grant standing too broadly. Now, just as an example, you saw that with the Mifid-Pristone case involving the abortion pill, in which certain doctors with religious objections to treating patients who have received the pill in the emergency room challenged the FDA's approval of that pill. A lower court judge determined that that they had standing, even though they weren't actually their supposed injury couldn't be traced directly to the government's approval. But nonetheless, the district court judge held that they had standing and therefore blocked the FDA approval of the pill nationwide. Now, the Fifth Circuit had to come in and stay and said, "Well, you're um, basically jumping the gun here." And stay that decision. But some of this, again, goes back to judges just being way too generous with their standing principles. Another issue is that the standard for granting legal injunctions, not just nationwide legal injunctions, hasn't been really enforced by the appellate courts. And it's a four-part test involving the you have to show that you're likely to win on the merits, will suffer irreparable injury without an injunction, as well as the balance of the equities are in your favor, and so is the public interest. And now, what's happened in many cases is that judges find, well, they're likely to rule on the merits, or in their opinion, they are, and therefore just enjoin it without actually considering the other three prongs of the test. So that's another problem. Now, going back to the universal injunctions, yes, they haven't, many judges haven't considered whether you could actually narrowly apply the injunctions to the particular parties and have just enjoined them just out reflexively. And again, this has mostly actually been a problem with liberal judges. in the first Trump administration, and increasingly now in the second. But some conservative judges are also guilty of doing this, especially in the Fifth Circuit. And I think the Supreme Court could provide some helpful guidance on this issue.
Alicia mentions a couple of the justices that are on record as skeptical of these injunctions. One is Clarence Thomas. In 2018, he wrote this: "These injunctions are beginning to take a toll on the federal court system, preventing legal questions from percolating through the federal courts, encouraging form shopping, and making every case a national emergency." Unquote. And he points to a couple of the advantages of the system of courts only granting relief to the parties that are in the case before it. One is that you get percolation through the system as appeals rise up. Different appeals courts, different circuits may come to different legal conclusions. But then when the ultimate appeal finally reaches the Supreme Court, the justices there have the benefit of many different minds chewing over the issue and maybe coming to opposite conclusions. But there is a real record, legal record that the justices can rely on as they are thinking through it. Another one is Justice Neil Gorsuch. A couple years after that line from Justice Thomas, he had a jab at injunctions of nationwide, universal, or cosmic scope. He said that they tend to force judges into making rush, high stakes, low information decisions. And he also pointed to the challenge here of if the government wants to implement any sort of controversial policy, it has to win every case nationwide, because if it loses one case anywhere, then the policy goes on ice until the appeal finally gets up to the US Supreme Court. So Monet, I mean, one outcome here might be, as Alicia suggests, some guidance from the Supreme Court reining in these kinds of injunctions and telling lower judges to think a bit more hard about those factors that she lays out, and what the actual appropriate relief is needed in any specific case.
Yeah, and I think it's interesting that, as Alicia points out, that four-pronged test for when these nationwide injunctions are to be applied already exists and is quite stringent. It should apply to a lot more cases, that there should be an inability of these district judges to block federal policies unilaterally. There, many more of them should not be fall under the ability to be enjoined than are in practice, and so I do think that the birthright citizenship case before the Supreme Court is an opportunity for the justices to re-articulate those standards and hopefully emphasize them and suggest some way, maybe even whether it's in the text of their decision or in some kind of discussion through the judiciary about how that will be enforced. But it's not as if there aren't already fairly clear rules that would, if they were obeyed by the lower courts, result in a much smaller number of these injunctions and probably more prudent selection of which cases should be enjoined. I think that it's interesting to think, for example, about some of these immigration cases, because I do think that um, the birthright citizenship case that's currently in court, and also a case that we might get into a little bit more under the Obama administration, in which the Obama administration decided to halt the deportation of the legal parents of U.S. citizens or of children who were brought to the U.S. Undocumented. Those both, I think, might fail that four-pronged test in terms of whether they should rightly be enjoined. Because, for example, someone who's denied birthright citizenship is certainly being harmed by the Trump policy. But are they being irreparably harmed? I think that you could definitely argue that they aren't. They would theoretically be subject to deportation and then removed to their home country or their parents' home country. But as long as they're a document that shows that they were born in the United States, then after the course winds its way through the Supreme Court and they rule against the Trump administration, they could order the government to repatriate that person. And the same thing goes for deporting those parents of U.S. citizens. If they were removed, they could be brought back, depending on how the Supreme Court ultimately rules. And so I think that it is important to have the ability to block some of these federal decisions that do actually cause grievous irreparable harm. But the courts need to really make sure that we're winnowing it down to only instances where that's the case, and to slap down some of these district judges who are clearly overreaching.
The difficulty may be threading that needle, Alicia, and I do worry that there have been complaints about the rise of nationwide injunctions, and I think that's true. For example, the Justice Department in its brief is saying that the Supreme Court that courts issued 14 universal injunctions against the federal government through the first 3 years of President Biden's term. By contrast, courts issued 15 universal injunctions or temporary restraining orders against the current administration in February 2025 alone. But the rise of these universal injunctions has gone in tandem, I think, with the rise of new executive pen and phone governance, huge assertions of power by the White House and the president. Monet mentioned one of them, the Obama administration's deferred action for parents who are illegally in the country but have U.S. citizen children. And former Texas Solicitor General a few years ago defended the injunction in that case and made the argument that there were 26 states that were challenging that. And the nature of the challenge was whether the government could say that this person was legally in the United States. And so it's not exactly clear, if there's not an injunction that applies everywhere, how a judge could block that policy at all. Could you have that deferred action taking place in 24 states? In which case, could parents leave the state of Texas and go to a state covered by a different circuit or not a party to the case and then get deferred action and then move back to Texas? Another example is the student loan write off that President Biden tried to push through, $430 billion dollars. The nationwide injunction in that case was from the Eighth Circuit. And the ruling said that they had considered a narrower injunction, but they were worried that there was no workable way to do that, to figure out which of those loans in that 430 billion pot were implicated by the exact parties, the loan servicer in the case before the court. That sounds like a real administrative headache. And by the way, maybe an opportunity for gaming the courts if the president wants to do that. Because if the Eighth Circuit says we are only going to apply this block to the parties before us, the states in the case, our circuit, then President Biden, I can only imagine, would have moved very swiftly to forgive debt for everybody else in a way that he would have argued later is permanent and can't be undone.
Right. So the Mohila case that you mentioned with the student loan, I mean, that was a kind of complicated case in part because of the question about standing. There were a lot of conservatives wanted to challenge the law, but it wasn't clear who would have the legal standing to do so. So Mohila, which was a student loan servicer, kind of a state arm of Missouri, stepped up to the plate and argued that this is a kind of a, again, it's a complex argument, but that it would be harmed because these only direct loans would be qualified for this student loan forgiveness, and therefore the FELP loans, which are held by private servicers or private lenders, wouldn't qualify, and then this would cause all the FELP loans that it held, those borrowers to try to consolidate it into direct loans, and therefore it would harm it. But you don't really know who or which. How to join this because who has the FELP loans and all that. So it's very thorny. So the cleanest solution was just to enjoin it nationwide. But to raise another example, and this gets to one of your points, is that Biden, after the Supreme Court ultimately blocked his student loan forgiveness, he came out with this kind of save, quote unquote, save plan that would provide another method of getting loan forgiveness, and who's kind of end running the court's decision here. And you got actually two Democratic appointees, lower court judges, that enjoined different parts of the rule of the save plan. And the Biden administration was that, oh, we'll find an end run. And they actually end ran one of those decisions. So the Eighth Circuit had to come in again and issue a nationwide injunction, essentially, because the Biden administration tried to actually get around and run the initial lower court's decisions. And so those are the cases where at least, appellate courts can step in. And I think they have an obligation to step in. The other example was with the Obama Clean Power Plan during Obama's second term. Eventually went up to the Supreme Court during Trump's first term. And that was a rule that had nationwide impacts. It was challenged in the Fifth Circuit. And I say it has nationwide impacts because it affected the electric grid. And so there really isn't any way to confine a ruling involving that to just particular states that were challenging that rulemaking, because energy produced in, say, West Virginia, or power produced there, and then invariably ends up, those electrons end up flowing to neighboring states and such. And any kind of stay or injunction that affected one state would invariably affect another state. And so the Fifth Court came in, and it wasn't quite an injunction, but it stayed the decision, and so did the Supreme Court ultimately. But I think what's important here, and to Monet's point, is that the Supreme Court needs to clarify when universal injunctions are necessary and can be issued, and when are the other circumstances that lower judges should consider before resorting to universal or nationwide injunctions. And I think that the problem is the lower courts have just been jumping. Their first resort is to issue nationwide injunctions before actually considering the alternatives.
One final thought about what will make this argument fascinating is it's coming up on the emergency docket. And unlike in cases that go through normal order where there's a lengthy record compiled and a clear, clean legal question presented to the justices, Monet, I'm not sure which way they're going to take this tomorrow. Are they going to talk mostly about birthright citizenship? Are they going to talk mostly about national injunctions? Those two issues are colliding here in an interesting way, and it raises the possibilities that there could be split rulings, or a partial win, partial loss for the Trump administration, maybe a ruling against it on birthright citizenship, but one that gives the Trump administration some victory on paring back the way that judges think about national injunctions. Maybe that is a John Roberts split decision. Monet, you get the last word.
Sure. I think the split decision is very likely. I think, yes, the birthright citizenship side of the case is quite clear, to the point that if it were only that being considered, the Supreme Court probably wouldn't have granted cert. But having done so, particularly the liberal justices are not going to miss their opportunity to articulate America's values and how important birthright citizenship is, and to flog the Solicitor General for even questioning it. And so there'll definitely be a lot of oral argument about that. And I expect that some of the merits of the birthright citizenship question will make its way into the decision. But then I do think that there has been building a lot of pressure on the nationwide injunctions question separately for several years. As you've mentioned, Clarence Thomas and other conservative justices have opined on it. The first few months of the Trump administration's second term have reached an apex in terms of these nationwide injunctions. And so the Supreme Court knows probably it's going to have to articulate some guidance about when those are appropriate, and it might not have a better chance to do so. So I do expect that they probably will curtail that in a way that sides with the Trump administration's argument, while giving a unanimous and very firm slap down to the birthright citizenship order.
Thank you, Monet and Alicia. Thank you all for listening. You can send your own injunctions to pwpodcast@wsj.com. If you like the show, please hit that subscribe button, and we'll be back tomorrow with another edition of Potomac Watch.